The Supreme Court of India has recently dismissed the election petition against DMK MP Kanimozhi. So this particular news is very important to both prelims as well as the mains examination, especially to the GS paper 2 and the subject Indian polity, because this news has got relevance to a number of constitutional provisions as well as the legal provisions with related to the Representation of People Act. So we'll just look into the facts of this particular case, and then once we'll understand the facts of this particular case, we'll also try to understand as to what are the legal and the constitutional provisions which is related to this particular news. Okay, so just come to the facts of this particular case. In May 2019, in the Lok Sabha elections, that is the 17th Lok Sabha elections, which was conducted by the Election Commission of India, Kanimozhi was elected as a member of parliament to the Lok Sabha, and in fact she was elected as a member of parliament from a particular constituency which is called as the Thoothukudi constituency. Now Thoothukudi constituency is a constituency in the southern part of Tamil Nadu, and after she was elected as a member of parliament from the Thoothukudi constituency, her election was challenged, her candidature was challenged, and her election was challenged in the Madras High Court. The very same month, the petition was filed in the Madras High Court. And what is the ground upon which the petitioner has made this particular challenge in the Madras High Court? That the candidature and the election of MP Kanimozhi was in violation of some of the provisions of the Representation of People Act 1951. And that is what the petition that was made in the High Court says. On looking further into the petition, the petitioner has stated that MP Kanimozhi has violated some of the provisions of the Representation of People Act, and to be very specific, MP Kanimozhi has not given the PAN card details of her husband. PAN card details of her husband in the election affidavit, because the petitioner has highlighted that anybody who is contesting election has to declare their assets and liabilities in the election affidavit, and not just the assets and liabilities of the petitioner themselves, and they should also declare the assets and liabilities of their family members as well, wherein this information has not been fully given by MP Kanimozhi, and that she has also not given the PAN card details of her husband, because the Representation of People Act and the conduct of election rules that also specifies that they should also declare the tax information, the tax return information when they file the election affidavit. And this is the petitioner, this was the allegation that was made by the petitioner when this petition was filed in the High Court. Now subsequently, what has happened after this petition was filed, MP Kanimozhi has given her explanation that this petition is not maintainable. It is because of the fact that her husband does not have the PAN card in the first place. Her husband was working as a consultant in Singapore, and that he doesn't have a PAN card in our country, and it is not possible for her to give this information in the first place, and hence this petition is liable to be dismissed because it is not maintainable in the first place. But however, the Madras High Court has not given any relief to Kanimozhi, and then MP Kanimozhi, and then subsequently she has made an application in the Supreme Court. And then the Supreme Court is looking into this particular matter. The Supreme Court has said that yes, this application is not maintainable, and because the petitioner has not given the relevant material facts, because if the petitioner is saying that the PAN card detail is not given, then it is a responsibility of the petitioner to provide the PAN card details so that the court can further look into this particular matter, and which has also been upheld in number of other cases. Whenever a petitioner is challenging the election of a particular candidate, and it is their responsibility to provide the complete material facts. The complete bundle of material facts has to be provided in front of the courts. Otherwise, the application would be considered to be very vague and incomplete, and hence it is liable to be dismissed. Stating the same grounds, the Supreme Court has dismissed this particular petition. So this is the fact with regard to this particular case. But how this particular news is related to some of the legal and the constitutional provisions, that is again very important for the examination. So what are the legal and the constitutional provisions? If you look into the constitutional provisions, first thing that should come to your mind is Article 102 and Article 191 of the Constitution. If you see Article 102 and Article 191 of the Constitution, it provides for the ground for the disqualification of the members of the Parliament, as to what is the ground on which they can be disqualified. Article 102 talks about the disqualification for the members of the Parliament. and Article 191 talks about the disqualification of the members of the state legislature. That's the understanding that you should have. Article 102 says that there are certain grounds on which a member of parliament can be disqualified. If any member of parliament is holding any office of profit, if any member of parliament becomes an undischarged insolvent, any member of parliament is giving up their citizenship, any member of parliament is becoming unsound mind, and in addition to that, if any member of parliament is engaging in any form of defections, political defection, that is also a ground for their disqualification. In addition to that, what is very important is both Article 102 and Article 191 talks about that in addition to all these grounds for disqualification, the article also empowers a parliament to make a law, and that law can also provide for the grounds for disqualification. And such a law is nothing but the Representation of People Act 1951. And the Representation of People Act 1951 also provides for a lot of grounds. And in fact, if you see the Representation of People Act 1951 and the conduct of election rules, they provide for certain ways to ensure the free and fair election in our country. And if you see the Representation of People Act 1951, the Representation of People Act 1951 says that intentional suppression of certain information is a ground for disqualification of a particular person, even if they get elected as a member of parliament. In fact, this was brought to the notice of the Supreme Court in this particular case by the petitioner. Rather, the petitioner has initially brought it to the Madras High Court, and he brought this, that MP Kanimozhi has intentionally suppressed the information with regard to the PAN card details of her husband, and hence it is a ground for her disqualification, and also that she has not filed the affidavit in an appropriate manner when she was contesting the election, and that is also in violation of the conduct of the election rules 1961. And therefore, her candidature should be disqualified and her election should be declared to be void. So, this is basically the argument that the petitioner has made. But however, there are few important provisions that you will have to understand this particular case further. The Representation of People Act 1951, and to be very specific, Section 80A of the Representation of People Act says that if any person wanted to file a petition challenging the election of a particular member of parliament or a member of state legislature, then the respective jurisdiction is the High Court concerned where the constituency falls. So, in this particular case, because Kanimozhi has got elected from a Lok Sabha constituency in Tamil Nadu, under Section 80A of the Representation of People Act, a petition was filed in the Madras High Court. So, this is something that you have to understand. So, the petition was filed in the Madras High Court. And if you look into Section 100 Class 1 Subclass D, it says that once a petition is filed, the High Court concerned can look into the merits of this particular case. And if the High Court concerned finds that there is a violation of any constitutional provisions, or if there is a violation of any of the provisions of the Representation of People's Act, or if there is a violation of any of the provisions of the conduct of election rules, so these may be the grounds on which the election of a particular candidate can be declared to be void. So, the Madras High Court actually had the power to declare this election to be void. So, what is your understanding that you should have for the examination? Where the election of a candidature for his election to Lok Sabha or to the Legislative Assembly can be challenged, it can be challenged in front of the it can be challenged in front of the respective High Courts. And will the High Court have the power to declare this election to be void? Yes, they have the power to do that under Article Section 100 of the Act. And in addition to that, you should also be aware of Section 83 Class 1 Subclause A. In fact, this was exactly taken as defense by MP Kanimozhi in this particular case. So, initially after the petition was filed in the Madras High Court, she argued that this petition is not maintainable. This petition, why it is not maintainable? Because the petitioner who is challenging that I have intentionally suppressed certain information in the election petition, and the petitioner has not given that particular information as to what I have suppressed. In fact, the petitioner said that I have suppressed giving the PAN card details of my husband. Then I have clearly stated that my husband doesn't possess a PAN card, and hence therefore it is a responsibility of the petitioner to provide that information in the petition that he has filed in the court. Otherwise, the petitioner is not giving the complete material facts, because the requirement under Section 83 Class 1 Subclause A, if anybody is challenging the election of any candidate, and it is their responsibility to provide the complete bundle of material facts as to what information they have suppressed. And if they are not able to provide that, then such a petition can be dismissed by the courts, and this is the well settled principle in the courts. In number of cases, this principle has already been followed. So in fact, the same argument was made by Kanimozhi, MP Kanimozhi in the Madras High Court, and subsequently the Madras High Court did not accept this particular petition that was filed by, counter petition filed by MP Kanimozhi, and rather subsequently she has approached the Supreme Court, and the Supreme Court has accepted this. The Supreme Court said that if a person is challenging her candidature and her election on the ground that she has not provided the PAN card details, then it is a responsibility of the petitioner to provide the PAN card details if she is already saying that there is no PAN card. And because the petitioner has not provided these information, this petition is not maintainable and it is liable to be dismissed, because under section 83 clause 1 subclause A, it is the responsibility of the petitioner to provide for this particular information. And stating this particular thing, the Supreme Court has dismissed this particular petition. So all these provisions may be very relevant for examination in addition to Article 83 of the Constitution. So what Article 83 of the Constitution says? Article 83 of the Constitution says that the election to the Lok Sabha shall be held every 5 years. So today we are in the 17th Lok Sabha, that is because the election to the Lok Sabha should be held every 5 years, and this article may also be relevant for the examination. So I hope this information that is given in this particular video will be very useful to the students preparing for the civil service examination. And if you want the PDF of this particular presentation, you can download it from my Telegram channel, Babu Gunasekaran 337. Thank you very much. All the best.